Straight ahead on Law and Crime Daily. Opening statements bring to light the gruesome details of the Todt family murders out of Florida.
Everybody needed to die in order to pass over to the other side together because the apocalypse was coming.
And
there's never been any acceptance of responsibility for your actions, Mr. Edgecomb.
a sentence is handed down in the deadly road rage shooting trial out of Wisconsin. Plus,
these doses of fentanyl that the defendant gave, ordered to be given, prescribed to these victims. This is the cause of their death, folks.
Closing arguments are presented by both sides in the case of accused murderer, former Ohio doctor William Husel. But first,
I'm here in support of Johnny Depp. I believe that he's innocent.
We're live in Virginia as actors Johnny Depp and Amber Heard go head-to-head in a defamation lawsuit. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm your host, Brian Buckmeyer. Jury selection begins in Virginia as Hollywood A-listers Johnny Depp and Amber Heard face off in a multi-million-dollar defamation lawsuit. That's where Law and Crime's Anjanette Levy joins us now live with the latest developments from day one. Anjanette?
Well, Brian, that jury was selected relatively quickly here at the Fairfax County Courthouse in less than one day. And those jurors will hear our opening statements on Tuesday morning in this high-profile Hollywood defamation case that has been years in the making. Bright and early, Johnny Depp fans lined the walkway of the Fairfax County Courthouse, hoping to get a glimpse of the actor, some holding signs that said, "Justice for Johnny."
It means getting justice for somebody who is framed for something that he didn't do. And he doesn't deserve to lose roles. He doesn't deserve to lose any of that over lies.
Christina Gibbons brought her 4 children from Minnesota to support Depp. The movie star is suing ex-wife Amber Heard for defamation. Depp says it happened in late 2018 when the Washington Post published this op-ed from Heard, where she wrote about being a victim of domestic abuse. Heard didn't name Depp, but he says that doesn't matter because everyone knew who she was talking about. Depp filed suit seeking $50 million, saying the op-ed cost him acting jobs. Virginia lawyer Gene Rossi on Depp's claim.
The burden of proof is much tougher for a plaintiff like Johnny Depp. He has to prove that his former wife, Amber Heard, maliciously, with reckless disregard for the truth, made an allegation that he essentially engaged in wife beating and domestic abuse.
Heard is countersuing for $100 million. She says Depp defamed her by calling her a perjurer and a hoax artist.
One of the greatest movies of all time is Animal House, and there's that famous scene with John Belushi, and there's a food fight, and everybody's fighting. This is a ex-spouse's food fight.
The testimony will certainly thrust the intimate details of Depp and Heard's tumultuous relationship into the spotlight. Heard posted on Instagram last weekend about going offline for several weeks, writing, "Hopefully when this case concludes, I can move on, and so can Johnny." Out of all of the fans outside the courthouse, only one was there to show support for Heard.
We're here to support Amber Heard because social media operations are harming her, and so we're not able to support her.
The remaining fans outside the courthouse say they don't believe Heard's allegations of abuse.
I believe the truth is that Johnny isn't this wife-beating monster that Amber says that he is, and I want the world to know that.
And you may be asking yourself, why is this case being heard here in the Commonwealth of Virginia at the Fairfax County Courthouse? And there's a very simple answer for that. Johnny Depp and his lawyers wrote in the lawsuit that they were filing it here because the Washington Post is published here in Virginia. And the servers for the company's website are in Virginia as well, some located here in Fairfax County. So that is why Johnny Depp chose Virginia, this Commonwealth here, in which to file this lawsuit. Brian?
Makes sense. Thanks, Anjanette. Joining us today is criminal defense attorney Karen Nance and co-host Terry Austin. Karen, Depp's defamation comes from the harm he says he suffered from Heard's essay on the Post. But like we heard, he wasn't named. So how is he arguing this harm?
Well, the article that was written was after the parties divorced. They were married from 2015 to 2017. And in that divorce, she argues that one of the reasons, or the main reason, was domestic abuse. So he's making that leap. And I don't think it's too far of a leap that the reference in the Post article was regarding the allegations she had made in their divorce. So that's how the link is made there.
All right, so a bit of a leap, but I would agree, it kind of makes sense there. Terry, as Gene kind of told us, this case involves two high-profile figures, different standards based on the law, but based on your experience in public relations, how do you think that will affect their case?
Brian, there's a famous quote by Bill Gates, and that quote is, "If I was down to my last dollar, I would spend it on public relations." Your public image is critical, and if the public loves you, his chances of winning in court is much better. And it absolutely seems, and it was based on Anjanette's, reporting there, that everybody is backing Johnny Depp, that people look at her as though she is an opportunist and that she's making this information up. So right now, in terms of the PR, Johnny Depp is way ahead.
Well, everyone but one, and of course we want to hear from our fans, of course, if you support either side in this case. Anjanette, we're expecting a star-studded witness list in this trial. What can you tell us about who's expected to testify?
Well, there are a number of people on the witness list for both sides. Amber Heard is expected to call Elon Musk and actor James Franco. They are expected to testify, if they do, via Zoom. And then Johnny Depp is expected to call Paul Bettany to testify on his behalf. So there are going to be some high-profile names coming up in this case. And, of course, Johnny Depp and Amber Heard are both expected to testify.
All right, it's going to give us a lot of insight into the relationship, and we'll see if these star-studded casts end up coming down to Virginia. Thank you very much, Anjanette, for your coverage. Still ahead on Law & Crime Daily, a sentence is handed down in the road rage trial of Theodore Edgecomb. But first, closing arguments are finally expected as ex-ICU doctor William Husel stands trial for the alleged murder of his patients. Welcome back to Law & Crime Daily. A jury is dismissed in the trial for former ICU doctor William Husel. This came Monday, just before the prosecution began its closing arguments. Husel is charged with the deaths of 14 of his patients for allegedly ordering fatal doses of fentanyl during his time as a physician in Mount Carmel Hospital's intensive care unit. Prosecutors claim the doses were excessive and accelerated the deaths. Husel's defense argues he was providing comfort care to the dying patients. After about 6 weeks of testimony and 53 witnesses, the defense called only one person to testify. Then, a day-by-day pause that lasted a week as a motion was filed in an attempt to get the judge removed. But that was ultimately denied. Monday morning, before closing arguments began, a juror was dismissed after the judge said it was clear he was been paying attention to media reports. Then, the prosecution began its closing argument.
There can be more than one cause for an event. And if the defendant's actions is one of those causes, it's not a defense that something else would have killed them too. If you hasten a person's death, even if their death is as sure as the sun is going to rise in the morning, if you hasten that along, you have caused their death. These doses of fentanyl that the defendant gave, ordered to be given, prescribed to these victims, this is the cause of their death, folks. Even though they were very critically ill, and perhaps some of them were on a trajectory to die very soon anyways, you cannot hasten their death. You cannot quickly, painlessly cause the death of a dying person.
Monday afternoon, the defense presented its final plea to the jury, saying the prosecution did not prove their case.
There was not one shred of evidence submitted to you as to why we're all here. Why will this man risk his family, his career, 17 years of trying to be a doctor, every single thing he has worked for, to hasten someone's death or to kill them? Specifically to kill them. Now you have a tough job because this is such a unique case. It's a novel prosecution. The mere fact of taking someone off life support, as you've all learned, is hastening their death. And not a single person has testified to you as to how long they would have lived without the fentanyl, or the Dilaudid, per se. How can you say it's going to hasten someone's death if you don't know how long they had to begin with?
All right, Terry, it's the million-dollar question. Do you think this was comfort care, or do you think William Husel is a murderer?
You know what, Brian, I've said this all along. In my humble opinion, I think based on the volumes of evidence that Dr. Husel provided comfort care, and I think that some of the jury is going to think the same thing. Once your vital signs are going down, once you start seeing your loved one grasping for air, or maybe they're wincing in pain, you are going to say, yes, please provide this comfort care. And Dr. Husel did what all of the others were doing. It might have been different doses. No one disagreed with him. And frankly, I think it was the right decision at the time. They may have questioned the methodology, but I think he did the right thing. And I think there might be some reasonable doubt in this case.
Karen, Jose Baez, as we saw there, kind of touched on this issue. The prosecution really never gave us a motive for these crimes. Now, they don't have to. It's not a part of the case or any case. But do you think that hurts their case in any way?
Yes, I definitely do. And I agree 100% with Terry's view of the case. What Baez did was very ingenious, I believe, in terms of how he presented it. We had no causation. We had no intent. In addition, he indicated and stated pretty strongly that there is no maximum dosage of fentanyl. He did focus on that. In addition, he indicated that the majority of the nurses sided with Dr. Husel in this particular in this particular case. So I believe he was presented a very compelling argument to the jury.
All right, well, let's see how it goes, because on one end, I get it from the prosecution. Why do you give fentanyl? Why do you give this much fentanyl? But as any good defense attorney does, Jose Baez is coming in and kind of just poking tiny holes there. Both of you are saying a potential hung jury. We'll see how it plays out. Thankfully, we finally got closing arguments in this case. But we'll continue to follow it here on the Law and Crime Daily, giving you updates on the trial as it progresses. Coming up on Law and Crime Daily, a father accused of killing his wife, children, and the family pet faces a jury for the first day of trial in Florida as the prosecution begins its case. Plus, how long will a man convicted of killing a Wisconsin attorney spend in jail? That's next, as Theodore Edgecomb learns his fate. Welcome back. Months after a guilty verdict is handed down, convicted killer Theodore Edgecomb is sentenced in the road rage trial out of Wisconsin. In January, Edgecomb was found guilty of first-degree reckless homicide. Edgecomb's conviction stems from the September 2020 death of Jason Cleereman, a Milwaukee immigration attorney. Edgecomb says he was riding his bike when Cleereman and his wife swiped him with their car. Video footage shows Edgecomb punching Cleereman through the open passenger side window. After that, the car follows Edgecomb. Security footage shows Cleereman eventually get out of the car and confront the defendant. That's when Edgecomb shot him. He was arrested 6 months later in Kentucky. While Edgecomb always maintained self-defense, he testified, quote, "The gun just went off." Before handing down a sentence, Judge David Borelski addressed Edgecomb's testimony.
Was not particularly credible. To say that, and you said it repeatedly on the stand, the gun just went off, when what the testimony was from multiple eyewitnesses was that you pulled up your hand and went like this, right at the forehead of the victim, and shot the victim almost directly between the eyes. That's not an accident. That's not a gun just going off. That's you brandishing a weapon and pointing it at someone's temple. I'm sentencing the defendant as follows, largely following the state's recommendation: 25 years of initial confinement, 12 years of extended supervision.
Terry, the judge almost implied there that this was a cold-blooded murder. Do you agree?
You know what, Brian? I agree in part and I disagree in part. I think when Edgecomb pulled that trigger, he was aiming to kill, and it did look like it was cold-blooded. But that initial claim of self-defense, that was plausible. He was trying to escape. He felt he was cornered. and he was trying to defend himself. The problem here is he got up there and he said it was an accident. You can't accidentally shoot someone when you're claiming self-defense. You're either trying to defend yourself or you are not. So he put himself in that position, and that's why the judge gave him 25. And I kind of agree with that.
Yeah, let's kind of talk about that 25 years, Karen, because I get the final moments as the judge is describing, but before that, he's kind of running for his life, Edgecomb. So for a case that didn't seem completely one-sided, are you shocked about the sentence here?
Well, it could have been worse. I mean, the jury could have come back with first degree, and they didn't. They came back with reckless homicide. I think that I would put the onus on the defense counsel in making that determination of calling Edgecomb as a witness. Now, would he have been successful without testifying at all with regard to self-defense? Probably not. But at the same time, more coaching, and sometimes you just can't, as a defense attorney, coach your client in terms of how to answer questions. But the judge indicated that he did not find Edgecomb's testimony as being credible with regard to the accident claim. So I think that didn't help him at all with the jury's finding. They found him not credible in that regard.
Yeah, and that one statement was very problematic, not just for the judges pointing out, but also for a self-defense claim. This seemed like a situation where maybe the defense should have prepped him a little bit more, and if he couldn't get to that point, maybe, as you said, Karen, he doesn't testify. But again, hindsight being 2020, we're not sure how that would have ended up. But thank you both. When we come back, a quadruple family murder just miles from Walt Disney World. What new details are revealed as opening statements are presented? Welcome back. Years after a quadruple murder and multiple trial delays, opening statements are finally presented in the case of Florida versus Anthony Todt, the man accused of murdering his wife, 3 young children, and their family dog. It happened in early 2020, just miles from Disney World in Celebration, Florida. That's where prosecutors say 45-year-old Anthony Todt murdered his family. Investigators found their bodies weeks after they were killed when officials attempted to arrest Todt on unrelated charges of insurance fraud. In a jailhouse letter to his father, Todt claimed his wife was to blame for the killings. On Monday, prosecutors described a potential motive behind the murder spree and revealed Todt spent days in the master bedroom with the bodies of his family members leading up to his arrest.
You're going to be informed by the defendant in his interview that he is the one that took the lives of Megan Todt, Alexander Todt, Tyler Todt, and Zoe Todt. Went into Zoe Todt's room while she was asleep, and he took the time to sit with her, and then he rolled over on top of her until she suffocated. The evidence will show that he did the same thing to Tyler Todt that he did to Alexander Todt. He suffocated Tyler Todt, and he also stabbed Tyler Todt in the abdomen. The defendant in his interview says that Megan Todt and himself had an agreement that everybody needed to die in order to pass over to the other side together because the apocalypse was coming. Right before he suffocated and took the life of Megan Todt, that he also suffocated Breezy the dog. And then the defendant says that after everybody was dead, he took all of their bodies and placed them all into the master bedroom.
Defense attorneys did not present an opening statement on Monday, a common strategy amongst defense attorneys. The trial judge told jurors defense attorneys will have an opportunity to present an opening later in the trial. Let's bring back criminal defense attorney Karen Nance and co-host Terry Austin as we get into the Todt family murder. Karen, what do you call the smoking gun in this case that the prosecution will try to hang their hat on to convict Todt?
Well, I think there are several. First is that he was in the home when the investigators came to the house to arrest him on an unrelated charge, and then all the bodies were there. Then we have the 2 confessions. Of course, one of them was excluded, but we still have a confession to use. And third, the fingerprints. His fingerprints were on the bottles of the drug. I believe it was Benadryl. Yes. And so those things really actually make it a very, very difficult uphill case for the defense.
Absolutely. Now, Tara, I think I heard a little bit of like doomsday, end of time. Sounds like a little Lori Vallow, Dave Vallow here. I know you like that case as well. But we heard opening statements and several witnesses for the state so far. Have you heard any evidence supporting the defense argument that the wife may be responsible for the deaths?
You know what? This case is moving very quickly. If you blinked, you may have missed it. The prosecution mentioned it in the opening, and you heard her say it there, that there was an agreement between the defendant and the wife, whose name is Megan, that they wanted to make sure they kill themselves because the apocalypse was coming and they have to all pass at the same time. But then we did hear the voice of Chrissy Caplet. That is the defendant's sister. She made a call to 911. It was following up on a wellness check. And the prosecution actually played that recording. And in the recording, she said she spoke to the wife, Megan, and the wife, Megan, did say something about the end of the world. So there's at least a little bit of evidence in there. It's been introduced that supports that defendant's position that it was his wife's idea as well.
All right, we'll see how this plays out. Maybe that eliminates one murder, but not them both. Thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.